Welcome back to Real Estate 101, where today we're going to talk a little bit about marriage contracts and cohabitation agreements. And I'm pleased to be joined once again by Todd Slonim of Devry Smith Frank LLP. Todd, welcome back to the show.
Thank you for having me.
Okay, Todd, so I want to start today's show and I want to ask you, is there anything a couple should consider before they move in together or they decide to get married?
Well, it's an interesting question. When a party is considering getting married or moving in together, they have to look at what they're bringing into a marriage. Often, couples may be coming from significant wealth or bringing in various assets that they want to protect. And so they should have a constructive discussion about those assets or their needs and look at ways of protecting them. So sometimes it can be an uncomfortable conversation, but a very important one. Another issue can be with cohabiting couples. It may deal with a couple who's at a different stage in their life, could be a second marriage, and they want to be more independent in their relationship, although together, and so they want to set out their affairs in a particular way that, although they are together, they are living sort of in a more independent fashion.
Right, okay. Now, what is the main reason you would say, if any, that a couple or even each party individually should speak with a family lawyer before entering into a marriage contract or a cohabitation agreement?
Well, there's a lot of complexities in the law, and it's important that each party understands what their rights and responsibilities are. So to have a full understanding of what they can or cannot do when it comes to a marriage contract or a cohabitation agreement, it is important that they get or obtain the proper advice from a lawyer.
Okay, Todd, does a marriage contract need to be signed before a couple gets married and a cohabitation agreement signed before they decide to move in together?
I think there's a common misconception that that is the case, but actually they do not. They can be signed well after the parties are married or when a couple does move in together. I would say that counsel would advise them to attempt to try to negotiate before these events happen, but they can certainly be done afterwards.
Okay, Todd, so what exactly does a marriage contract and cohabitation agreement do or provide?
Okay, so there are certain elements or areas that those contracts or agreements can provide for. One of the areas is the ownership or division of property. So the agreement can state what assets and liabilities will be excluded, how property will be sold, with the exclusion of the exception of the matrimonial home, property that will be sold, how it will be valued, and will that value be shared? Will property not form part of the equalization process? So those are all very important concepts. Another area is spousal support. Will it be paid, or will there be a waiver support? How will finances be dealt with and the needs of the parties during the relationship? Child support can be dealt with, provided that it is reasonable in accordance with the child support guidelines. If a matter, for instance, were ever to go to court, the court has to apply or must apply the child support guidelines. So a court will be cautious by looking at terms that are provided in the agreement, and they will only apply the terms if they feel that it's a benefit to the child and it is not inconsistent or necessarily inconsistent with the child support guidelines, and they feel it's in the best interest of the child.
And is there any other areas those agreements and contracts can cover?
Yes, there actually are two more areas. One is the education and moral training of the child, but it cannot deal with custody and access. And there's sort of a catch-all where it can deal with other areas regarding the settlement of affairs, provided it's not specifically excluded under law.
Okay, Todd, is there anything that a marriage contract and cohabitation agreement cannot do?
There are a few areas. Parenting terms, for instance, custody and access cannot be dealt with by marriage contracts or cohabitation agreements. That's more appropriately dealt with by a separation agreement, or if a matter goes to court, by a judge. Also, these contracts or agreements cannot restrict a married spouse's right to possession of the home. Each spouse has an equal right to stay in the home, so if a term suggests otherwise, that will not be permitted. One of the other issues in the same area is that if the agreement suggests that the home should be sold, encumbered in some way, let's say by a mortgage, prior to the parties being divorced, that will also not hold water. Once they are divorced, then that is more appropriately, again, dealt with by a separation agreement or by a court order.
And what about arbitration? Is that something that's not covered with these agreements?
That's actually something that is more appropriately covered under a separation agreement, as opposed to the as opposed to the marriage contract or the cohabitation agreement. Also, issues related to child support. If a provision provides for payment that is less than what the child support guidelines state, you have to be very cautious about that deviation, and the terminology has to be written very carefully. Again, that's why one would speak with a family law lawyer. Another aspect, if there's a provision that deals with one party paying spousal support but getting a income tax deduction to the payor, but the recipient spouse is including it, and they are living in the same residence, that is a problem, because the Income Tax Act deals with separated spouses, payment from one separated spouse to another separated spouse who are not living together. And so what you are looking, often where this occurs, is where one spouse is trying to get a tax benefit of some sort by paying the spouse support, getting tax deduction, and getting a better tax rate from the lower earning spouse. And so that's something that would not be permitted as well.
Okay, Todd, so what rules should a couple follow in order to avoid making an agreement that won't hold up?
Okay, well, that's a very good question. Agreements have to be signed, they must be in writing and witnessed. But fundamentally, the parties must understand what the contract says, which the courts have interpreted to get independent legal advice. So it's important that they appreciate what they're entering into. There should be full financial disclosure, full, open, complete disclosure. If that does not occur, an agreement can be set aside. And otherwise, you don't want to offend the laws of contract. So issues of duress, duress, fraud, undue influence, things of that nature can severely impact the agreement and expose it to being set aside.
Okay, Todd, so is there any concern with a couple that is about to enter into a marriage contract before their wedding?
We have to look at timing. We have to be very careful about when they are trying to enter into a marriage contract. It would be not favorable for a party to be entering any kind of agreement 2 months prior. There's a lot going on. People's focus is not on the agreement, but on the wedding and wedding plans.
Right.
So there are concerns about influencing one of the parties, especially if one of the parties really wants the contract. And there may be an expectation that the person will sign. They don't want to be embarrassed by canceling a wedding. And so we do have to be mindful of this. So there should be an appropriate amount of time given. Where a parties cannot negotiate the contract in advance of the wedding, they can enter a standstill agreement which says, we'll treat the parties as if they weren't married even though they are married. And so issues as of the payment of spousal support and equalization payment will not be factored in. It'll be considered as if they were unmarried. And a standstill agreement is only for a variety of months to permit the parties to continue their hopefully positive negotiations to get a final result.
Okay, so should couples pay special attention to support terms in a marriage contract or cohabitation agreement?
Spousal support is a tricky area, and certainly if courts will pay special attention to the circumstances surrounding the agreement and how it was entered into, especially with regards to the payment of support. So if terms are somewhat unconscionable in terms of when the agreement was first arrived at or when it's been brought to court, they could set it aside. Another issue is if the terms provide for support or a waiver of support where a person has public funds available to them. Another area is if there is a default on the payment of support, a court can also look into the terms and set aside issues related to spouse support, the payment of or a waiver.
Okay, Todd, so let's say a couple signs a marriage contract here in Ontario and they move to another province or country. What happens?
Well, we have to be mindful of that move. Ontario law recognizes both marriage contracts and cohabitation agreements, but the foreign jurisdiction may not. So they may run into problems about how that contract can be enforced. For instance, on separation, Ontario law deals with the division of property. And the issue of the division of property, according to Ontario law, may not be recognized in that foreign jurisdiction. So enforceability is a large problem. Fundamentally, what parties should do is if they are aware that they are going to be moving to a new jurisdiction, they should speak with a lawyer of that particular jurisdiction and get advice as to the enforceability of the agreement, or if they need to make changes to the agreement by way of an amending agreement.
Okay, Todd, so for today's final question, I want to ask you, can one party or both parties to an agreement simply decide to walk away or not abide by its terms?
That is usually quite difficult. Normally there are terms in an agreement that state that if there needs to be a change to the agreement or some type of amendment, the parties will enter into a further written agreement which changes the terms of the agreement. So simply saying I don't want to abide by it does not necessarily release you from the agreement. Now, there are certain exceptions, perhaps, which deals with the conduct of the parties over time. So for instance, if it can be demonstrated that they are acting in a way that is inconsistent with the agreement, a court could set aside those provisions. So for instance, if the property provides for property to be held separately and distinct, but the parties actually put it in both names or in the names of one party alone, and that was the course of conduct throughout the relationship, a court may not put any weight on the terms of the agreement that specifically provide for the original independence of the property and could set that provision aside.
All right, Todd, thanks very much for coming on today's show, and I'm looking forward to seeing you again sometime in the future.
Thank you for having me.
So there you have it. If you're about to get into a marriage contract or cohabitation agreement and need the help of a top family lawyer, get in contact with Todd Slonim at Devry Smith Frank LLP. I'm your host, Joe Terceira. Thanks for watching, and we'll see you next time.